While criminal law largely deals with cases where the state is acting against a citizen, the civil process involves different individuals, companies or groups using the legal system to resolve their disputes. For instance, if somebody had been involved in an accident in a hospital and believes it was as a result of the negligence or bad practice of a nurse, then they may make a claim for damages. District judges deal with the majority of court cases that come to the county court, but rather than do them in a courtroom, they're done in the district judge's office.
It is my job to encourage the two parties to a dispute to cooperate, and I try to help them settle their dispute. I often encourage the parties to use methods of alternative dispute resolution in order to come to an agreement. These two here are two barristers who are here to resolve a personal injury case. And this will all be done in my chambers. And we won't be wearing our gowns and wigs.
This is the civil court structure. The structure used to involve a significant role for the magistrates' courts in relation to family law matters, but this was changed by the Crime and Courts Act of 2013, and now, with the exception of the recovery of council tax and charges for water, gas and electricity, the magistrates' courts are not part of the civil court structure. The County Court and High Court are the courts of first instance in the civil court system. Smaller value and fast-track claims are heard first in the County Court, while higher value claims start in the High Court. The County Court was introduced in 1846 to provide a local accessible forum for adjudication of small-scale litigation. County courts are served by circuit judges and district judges. The small claims procedure is a major success of the civil justice system. Rules and procedure are designed to ensure that ordinary people with limited resources can afford to bring an action. The main advantage to litigants using the small claims procedure is that they can take or defend a case without the need for legal representation and without incurring legal costs. Cases are dealt with by way of an informal hearing by a district judge. Appeals from the county court on questions of law or fact go to the civil division of the Court of Appeal. The High Court of Justice was established by statute, the Supreme Court of Judicature Acts of 1873 and 1875. The constitution and jurisdiction of the High Court is now governed by the Supreme Court Act of 1981. The High Court has three administrative divisions: the Chancery Division, the Queen's Bench Division and the Family Division. In most cases, the Court of Appeal is the final Court of Appeal. Only a small number of cases are appealed to the Supreme Court. In June 2003, the government announced that it planned to transfer the jurisdiction of the House of Lords to a new Supreme Court. This was confirmed in the Constitutional Reform Act of 2005. It was decided that the new Supreme Court would consist of 12 judges and the current Lords of Appeal would become the first members of the new court. Although the Constitutional Reform Act was passed in 2005, the provisions establishing the Supreme Court were not brought into force until it could be properly housed. The venue chosen was Middlesex Guildhall in Parliament Square, and the planned refurbishments took until October 2009 to complete. The jurisdiction of the Supreme Court is broadly the same as that which was exercised by the House of Lords. It hears appeals from all parts of the United Kingdom and remains legally separate from the existing courts of England and Wales. Justices, known as My Lord or My Lady, will hear about 100 appeals a year, and a panel of 7 or 9 justices sits more often.
So as you can see, I work within quite a complicated structure, but most civil cases are still dealt with here informally in my chambers.
I'm a barrister, which means that I represent my client here in front of the district judge. Barristers don't just specialise in criminal or civil law, as civil law has a wide variety of aspects, including, for example, contract law, law of tort, family law, company law, employment law, land law, copyright and marine law.
In this case, I'm acting for the claimant. One big and very important difference between civil law and criminal law is something termed the burden of proof. In a criminal case, something must be proved beyond a reasonable doubt. This is a very high level of proof and is in place because a conviction could result in a defendant having to serve a long prison sentence. But as this is a civil case, I only have to prove my claim on the balance of probabilities. This is a lower level of proof and basically means that the judge decides who is most likely to be right. So in theory, in a criminal case, a defendant could be acquitted or found not guilty, but the same facts presented in a civil case could find the defendant liable. These circumstances aren't common, but they have happened.
In English law, we have an adversarial system. The adversarial system works on a contest model between two parties, with their aims being to win the case.
My job is to present my client's case in the best possible light. I do this by examining witnesses I have called and by cross-examining witnesses called by the other side. The judge's role in this system is quite a passive one. A neutral umpire, making sure that both sides comply with the rules of the court and deciding which of the two versions is the most credible.
Well done. Thank you.